If you have $18,000 in savings, will that disqualify you from receiving Medicaid? My mom makes less than $2,000 a month. She has a ladybird deed. Is her bank account protected with the ladybird deed? Man, I wish that was the case. No. Unfortunately, your bank account is not protected or in any way tied to a ladybird deed for Medicaid qualification purposes. Now, the good news is it's very smart to have a ladybird deed because that does keep the home away from probate or outside of probate. It'll pass directly to the beneficiary, beneficiaries, or trust listed on the deed, whoever she chose to list on the deed, whether it was multiple people, one person, or a trust. It will go there directly, bypassing probate. In Florida, Medicaid doesn't have any claim or can't put a claim against Homestead, especially when it passes this way through a ladybird deed. And then, of course, the added benefit of the ladybird deed is you can avoid the time and stress and money associated with probate. So very well done on getting a ladybird deed in place. Also, another silver lining, the fact that she earns less than $2,000 a month. And as long as her gross monthly income is under $2,901, which I'm assuming that it is in this scenario, but let's just say if the gross is under $2,901, her monthly gross, then her income is not going to be an issue for Medicaid qualification either. So receiving $2,000 a month gross in income is allowed. And you can still qualify for Medicaid. You can receive up to $2,901 a month in income. Now, assets are different, and money in the bank is considered an asset. That's separate from your homestead, and that is separate from your income. So money that you have sitting around in a savings account or money invested in a brokerage account, some kind of stocks or anything like that, anything that you can make liquid and get your hands on. She could easily take that $18,000 out of the bank. That is a countable asset for Medicaid. What can you do? What should you not do? So first and foremost, you should not gift that money, or she should not gift that money to anyone if she's trying to qualify for Medicaid soon, or within the next 5 years, because if she tries to give that to family members or to you, then she will be penalized by Medicaid, and she might as well just spend the money or spend it down or spend it on the nursing home first. So she should not gift the money. However, if you're in Florida, there are ways that this money can be utilized and therefore get her asset level down to $2,000, or you're allowed a $160 allowance too, so $2,160 in her bank account. Because essentially that's what you need to show Medicaid, is that during the month she had at least one day where her bank account was not over the $2,000. And you also, of course, allowed $160 for an allowance that Medicaid permits. So what are the ways? One, you can look into buying a burial policy. Any kind of insurance policy, though, you have to be mindful of the fact that if there's a cash surrender value associated with it, then the cash surrender value is treated as an asset and could prevent you from qualifying if it brings you over that $2,000 limit. But that is one way to spend down some of the money. Two, if she is going to be going into a facility, there's usually expenses related to that. Moving expenses, sometimes a security deposit is required. Certain things that maybe Medicaid isn't going to cover, so that's something to look into. Now, what you could do for the bulk of the asset, one of the things that we recommend a lot to our clients, especially in this scenario where they have a child or children and they would rather that money go to that child or children rather than need to be spent down or utilized on nursing care before Medicaid can kick in, is putting together what's called a personal services contract. I have another video on this, so I'm not going to go into it in depth here, but essentially it's a way where money can be transferred to a child in a lump sum in exchange for services. So the child has to be acting as a caregiver. And some of the services that can be provided as a caregiver are driving a parent to and from appointments, doctor's appointments, nail appointments, hair appointments, picking up dry cleaning, doing laundry, helping them balance their checkbook, delivering food, cleaning, delivering supplies. I mean, you can have separate categories, some financial, like helping to balance checkbooks or paying bills. Some can be related to running errands. But there's essentially various types of activities that you could assist your mom with, or that you could do for your mom, that can fall under the broad umbrella of caretaker services. And depending on your mother's age and life expectancy, because that's what these contracts are based off of, you may be able to transfer $16,000, or basically the entire amount that she needs to get rid of, from her to you after a personal services contract is signed. So first you'd have to have the contract drafted by a qualified elder law attorney who knows what they're doing. So this contract could be drawn up. It would then be signed by your mom, or if you're able to sign one as an agent under her power of attorney, meaning if there's a section in there that allows you to sign a document such as this, and she does have a power of attorney. So as long as it gets signed and it's technically on or on behalf of your mom or by your mom, then once it's signed, the money can be transferred from her account to you. Are there any drawbacks with this? So depending on how the contract is drafted, and in most scenarios, the person who is the caregiver under the scenario, so if it is you as the child, that money that gets transferred is income. So you have to consider it needs to be reported as income, and taxes are often needed or most likely needed to be paid on it. If that is the case, though, the taxes can just come out of the money once it's transferred. Again, it does have to be transferred in a lump sum. So this isn't something that can just sit in mom's account and be transferred to you little by little. It would be transferred as a lump sum, and any taxes that would apply would be paid in one calendar year. But oftentimes it's way better to potentially need to pay some income tax versus needing to spend down the entire $16,000 to qualify for Medicaid, or not being able to qualify until you spend that down. So that is an option. There's also the option of a pooled trust, especially in scenarios where there isn't a person available to be a caretaker. If there's not a person who the Medicaid applicant trusts to put in that position, then a pooled trust can be set up where these funds can also be transferred into a particular type of trust. The trustee of that trust is a nonprofit organization. They can use the money on mom during her lifetime. In this scenario, though, the money does go to Medicaid after she passes away, unless it can be transferred to a spouse who's on Medicaid. So that's one big difference between the pooled trust and the personal services contract is, in the personal services contract, you can still spend the money on your mom if you want while she's alive. I mean, it's technically your money, but you can spend it however you want because it's your money. But then whatever's left over, your money, because it's always been your money as compensation. In a pooled trust, that's not the case. The money that's transferred into the pooled trust can be utilized for mom's benefit during her lifetime. However, what is left over, Medicaid is allowed to reclaim based on monies they spent. So they can submit to get paid back out of the pooled trust, and typically this is what happens. Again, unless there's a spouse who also needs Medicaid, the money can be transferred to a spouse's account, but that's it. If that's not a possibility, it's going back to Medicaid most likely. All right, so I hope this provides some helpful insight on what can be done when there is an asset that's over the limit. And yes, a bank account is a separate asset from the home. So if you have money there, it is going to be considered a separate asset. It's not going to be tied to the home. If you have any other questions about Medicaid or elder law, estate planning in general, and you're in Florida, don't hesitate to reach out to us. We're at atCAUSE Law Office, the non-stuffy attorneys, and the link is in my bio.